true. If it's clear error of a fact, then throw that fact out. When it comes to legal issues, you can look at the law, look at all the laws that have been provided. They want to say the Fifth Amendment to the Constitution doesn't apply to you. Interlocutory appeals were made in Ashcroft v. Iqbal, 2009, which involved First and Fifth Amendment constitutional rights. Ashcroft allowed plaintiff to seek an interlocutory 1292B appeal if the denial hinged on a novel constitutional issue. Masters v. Soto hinges on a novel constitutional issue. Do we have a right to a grand jury indictment, or don't we have a right to the Fifth Amendment? Do we have the right to the Fifth Amendment, or don't we? How come the fucking Wolpert and the district judge and the fucking magistrate, why are they too afraid to answer that question? They can't confirm it nor deny it. They're going to try to sidestep it. They're going to try to supersede it. They're going to try to fucking smash it down and say, oh, look at this other fucking goddamn legal mechanism. In Ashcroft v. Iqbal, 2009, the magistrate recommended denying summary judgment for the defendants, and the district judge adopted that recommendation. The Supreme Court reversed the appeals court decision, which made the interlocutory appeal successful, and the summary judgment held. The summary judgment held. So the magistrate recommended no to the summary judgment. The district judge says, you're right, fuck the summary judgment. The appeals court upheld the district court, but the Supreme Court overruled the appeals court, the district judge, and the magistrate. And so the summary judgment held. In Behrens v. Pelletier, this is a 7-2 Scalia opinion. Are you ready for this Scalia opinion? In Behrens v. Pelletier, 1996. A 7-2 Scalia opinion. The magistrate recommended a summary judgment denial, which was adopted by the district judge. Defendants appealed interlocutorially, and they were successful. Behrens illustrated a successful interlocutory appeal which overturned the denial of summary judgment over a fundamental right. So the magistrate wants to say, who gives a shit about summary judgment? We're going to say fuck the Fifth Amendment. Nah, we're not going to rule on summary judgment because fuck you, American citizens. You don't fucking matter. If we want to kidnap your ass and throw you in a fucking jail without a goddamn grand jury indictment, breaking your Fifth Amendment, fuck you. We're allowed to fucking do that because fuck you. You're just a citizen. You're nothing. You're nobody. You're less than nothing. You're fucking less than the shit on our shoe. I'm a fucking magistrate. I'm a district judge. I'm an appeals judge. I'm important. I protect the billionaire class. I protect the fucking lying-ass lawyers. I protect the fucking goddamn thieving-ass corporations. Give me $600. Thanks for the $600 and fuck you. You don't get your rights. But thanks for the $600, fucking thieving-ass motherfuckers. In Behrens v. Pelletier, 1996, Scalia, the Ninth Circuit's one interlocutory appeal rule is rejected. So they try to say, you're only allowed to file one interlocutory appeal. Only one interlocutory appeal. An interlocutory appeal is a appeal before the appeal. And there's like 3 different categories of when that's okay. Behrens declared that both a refusal to grant a defendant's motion to dismiss or a denial of summary judgment are appealable final orders. Scalia wrote that the denial of summary judgment is more final than a motion to dismiss. So, we'll leave that up for the ages. But what do you think sounds more final? You come up to me and I say, we're going to go ahead and approve the motion to dismiss. We're going to say, fuck your summary judgment, and we're going to dismiss your case because fuck you, you're just a goddamn citizen. You don't matter. You don't get your Bill of Rights. You get no freedoms. You're just an American citizen. You don't get any freedoms at all. So, is the dismissal or the rejection of the summary judgment, which one is more final? Summary judgment means that they're going to go ahead and judge it based upon the law. All the facts are agreed upon. The dispute that we need to resolve is a legal dispute. Isn't that what the fucking magistrates and judges, don't you know the law? Aren't you an expert of law? So if there's a summary judgment opportunity, take it. We agree on all the facts. So all we need is a judgment based upon law. So if they just dismiss it for whatever reason, no fucking cause of action or some shit, according to Scalia, to reject a summary judgment is a bigger deal than to accept a motion to dismiss. I mean, I don't, they're comparable. I don't really have a opinion myself on the matter, but that's pretty fascinating to me. Motion to dismiss sounds pretty conclusive, but according to Scalia, saying no to a summary judgment is worse than a motion to dismiss, according to Behrens v. Pelletier, 1996 Supreme Court case. Indeed, it is easier to argue that the denial of summary judgment, the order sought to be appealed here, is the more final of the two orders. Denying summary judgment is more final than the dismissal, according to Scalia. I got a couple more cases here, but I'm going to take a break. But Al-Kid v. Ashcroft, Scott v. Harris, Roel v. Withrow. Roel v. Withrow is another fascinating case, which is actually right up our alley. Roel v. Withrow talks about all the issues that I have brought up so far.